That is the part of the great cultural change that occurred during the Nixon administration. When I first started practicing law, there were very few what you would call professional prosecutors. You had a pool of lawyers somewhat similar to England, and occasionally they'd serve as prosecutors for a term or two and then go into private practice. The young lawyers would. Once in a while you'd have an old lawyer that stuck around for a while. But you didn't have the well-trained, specialized prosecutors that you do after the Nixon years under Attorney General John Mitchell. So for instance, in Chicago, where I first started out, all of the prosecutors, called state's attorneys there, could have part-time practices out in outside hours. So they interacted with the general public a little bit. To that extent, they got adjusted or got to know the general public and look at people as clients or potential clients rather than criminals. Now, one of the problems with the professionalization of criminals is that the prosecutors tend to get tunnel vision. And it's kind of like the adage, if all you've got is a hammer, everything looks like a nail. And that's what happens with the privatization and also with the specialization of prosecutors. In England, the barristers, which are the trial lawyers, they try cases on both sides, so they don't become biased. That's not the case in the United States. And it's complicated. You have to get into the whole construction of reality thing and postmodern social theory and things like that. But essentially, it comes down to construction of reality. What is the reality of various people? Well, people construct their reality out of their environment, what they see, what they believe, what they do, and the feedback that they get. So feedback loops become very important. And if you have narrow feedback loops, you're not going to get as broadened as if you have wide feedback loops. So let's see, we talked about apocalyptic thinking. Well, if you think the world's going to come to an end unless you do something, you're going to have to look in that frame of reference. That's going to be your reality, and your job is going to be to prevent the sky from falling, to prevent all kinds of disasters. And your job is to prevent disaster and treat disaster and punish disaster or even potential disaster. The next thing that happened was not only was the element of specific intent in crime abolished, but they also changed the rules of evidence to make it easier to prove things. So you have specialization, abolition of specific intent, and changing the rules of evidence. All of that led to more convictions and easier convictions, and also more power in the prosecutors. So a lot of people, a lot of public want to look at things like this behavior or that behavior, but they don't analyze or look at things in terms of power. Who has the power to do what? Who has the power to make decisions? And in our modern system, the power lies generally with the prosecutors, with the judges as rubber stamps. And that's because a lot of the judges come from the ranks of the prosecutors. The public has been brainwashed to think that the only thing in government that matters is efficiency. And I'm here to tell you that efficiency and democracy and efficiency and justice are mutually exclusive terms, but nobody seems to want to appreciate that. So we got an efficient court system. How do you get an efficient court system? You block impediments to the goals, which is to lock people up and make people safe. Sort of like a management by objective principle. You find what the objective is and you fulfill that objective. And opposition be damned, you're just going to go ahead and do it. So we have that idea brewing, and that's brewing in the culture. And remember, the court system is a third branch of the government. Maybe not as big as the other two, but it's a separate branch. It's a separate institution, and it has its separate culture, separate folkways, mores, etc. And in a lot of ways, it's very traditional and older than the other forms of government. If you go to England, for instance, you see the various rituals that are attendant in court proceedings, like when I watched in Old Bailey in London. They had the wigs on, the judges had the silk robes, and the barristers presented their cases. And the barristers were hired by one side or the other. And they would take either side or the other depending upon who was paying them. But the whole procedure was steeped in tradition and strict tradition. And that's what differentiated the legal systems of the United States and England. So let's talk about professionalization for a minute. Now imagine yourself a young lawyer right out of law school, and you get a job with the prosecutor's office. Your circle of friends and acquaintances and the feedback loop from which you get your theories and your views and your ideas are other prosecutors. And in this country, the prosecutors pretty much are put into office by the police, who vote as a bloc. And the only people that prosecutors talk to ordinarily are officers, and the officers always are giving their point of view. And pretty soon the young prosecutor has no way of checking his reality. There's no reality checks. He hears the officers complain about this, complain about that, complain about the judges, complaining about other prosecutors and the prick lawyers and things such as this. And they start developing that even though it's not conscious, I guess. So one of the things that has been going on for at least almost 100 years that I know of is that police view their jobs not as maintaining order or helping the public, but in not keeping the peace, but to arrest and punish and prevent an apocalypse from happening. So if they don't stop this criminal or whatever, the world's going to come to an end. So you get somebody who's fleeing a scene, and you want to make sure he doesn't harm somebody else. So what do? You shoot him. If somebody doesn't want to talk to you or whatever, or you think he commits a crime and he won't admit it or confess to it, you beat the shit out of him and get him to confess. And that was the way law was during the Prohibition days and thereafter, until they started applying what they called due process standards to the law. And when they started doing that, there wasn't any disagreement to speak of within the federal system, but the states started bristling at the fact that they were getting regulated. And a lot of them took it as an affront to their integrity or competence or whatever as far as regulation of things such as search and seizure, confessions, right to counsel, etc. So again, you're the young prosecutor, and what happens? You go into court, and the officer has brought a case, and your job is to prosecute it. And you go through the files, and you think, this search isn't good. Now, if you're really green, you're going to tell the cop this is a bad search. And the cop's going to argue, and he's going to say, well, who cares? It's a righteous arrest. The guy's guilty. I caught him with this stuff. What difference does it make how I got it? That's technical. That's a technicality. Well, it's not a technicality. You've either got the law or you don't have the law. If the Constitution is the supreme law of the land, you don't make it subsidiary to regulations or to the whims of police officers or prosecutors. And if they don't want to follow the Constitution, then they should get another fucking job. And that's my view, succinctly and shortly. Police officers take an oath. Other participants other than judges don't take oaths. And it's worse to violate an oath than anything. It's an act of dishonor. And you would think people empowered by the right to kill others, to arrest others and impede their freedom or other things would at least follow their oaths of office and honor those oaths of office, not think they're above the law and can violate it at any time they so feel. Well, our young prosecutor has a career and a successful career as a prosecutor and moves through the system. He might start at traffic court or county court and then move up to where he's prosecuting low-grade felonies, and eventually we'll get into where he's prosecuting murder trials and other serious offenses. And all this time looking at his cases from the point of view of a prosecutor. Now, lawyers are supposed to advise clients. Prosecutors are supposed to represent the interest of society, the interest of the state. They are not supposed to be mouthpieces of the police. They are not supposed to be advocates for the police. They're supposed to be advocates for law and advocates for society. And somehow we've lost sight of that. The police don't think they're advocates for society. They don't think they're representatives of society, and they don't think it's their job to figure out what is best for society. Their job is to get bad guys, lock them up, and get them out of the way, get them off the street. Protect the public from apocalypse. Well, that ain't the case. But when you've got this specialized prosecutor, they don't know any difference. So the difference between a private lawyer, for instance, and a state-paid prosecutor is those of us in private practice, a client comes in and we tell them you can do this or you can do that. You discuss the problem and you advise them. At least that's the way it used to be. I probably turned down as many cases as I've taken because there's something wrong with the case or there's something that I wouldn't feel comfortable presenting, etc. And I view a lot of defense attorneys, particularly the older ones, different than the young guys because they feel their job is to get a conviction. Prosecutors my age would say to the cop, they would view their job as advising the cop. And they say, you guys are wrong. You can't do this. and you can't do it this way. You can do this, but not this way. And they actually advised the public. They advised the people. They advised all of their officers. They didn't let the officers set policy. And they didn't let the officers bitch about this, that, or the other that they didn't like or thought was an affront to their competence or their function as policemen. So next we're going to talk about the attitude of bail or bail bonds and how that has changed.